Good morning. Welcome to this morning's Countryside Rights of Way panel. Thank you for Zach to be here. Thank you, team, for your support today. And welcome to those members of the public that are sitting in. So welcome to you as well. Can I formally take apologies for the meeting? Do we take them as read, or do you want to?
Good morning, Chairman. I've received apologies from Councillor Worthington, Councillor Hudson, Councillor Pritchard, Councillor Waring and Councillor Snape.
Fine. Any declarations of interest for this morning? No? Thank you very much. Minutes of the meeting held on the 11th of August. Those have been circulated. Does anyone have any comments on the minutes from last time? No? We're all agreed. Okay, thanks very much. Do I have your approval for the minutes? Minutes are approved. Right, let's move to item 4, Wildlife and Countryside Act 1981. Application for an alleged public footpath from Fradswell Lane to FPO 1410 Fradswell. Thank you.
Thank you, Chair. This is an application for an addition of a public footpath from Fradswell Lane to footpath 0.1410A Fradswell. The line of the route can be found at Appendix B to the report. I can confirm that I've received no objections or representations from the local member. Moving to the recommendation. Which is that the evidence submitted by the applicant is sufficient to show that a public footpath is reasonably alleged to subsist along the route at Appendix B, and that an order should be made to add the alleged right-of-way to the definitive mapping statement for the Borough of Stafford. The application is based upon historical evidence. The applicant submitted the deposited railway plan and book of reference for the proposed Staffordshire and North Midland Junction Railway of 1845, the Fradswell Tithe Map and 3 Ordnance Survey plans dated 1879, 1836 to 1840 and 1901. As members will be aware, railway plans were produced by the railway companies for major schemes of work and were authorised by private acts of Parliament. From 1838, these plans and the associated books of reference were required to be deposited on the local public authorities. While they may provide only supportive evidence for applications considered on the higher test, the balance of probabilities, they can be sufficient as evidence in cases of reasonable allegation. The 1845 deposited railway plan shows a plot separate from adjacent land holdings and marked with the number 46A. The book of reference for this plot refers to it as a parish road and the owner recorded as the surveyor of Fradswell. The annotation is good evidence that the route was considered public and sufficient to satisfy the lower test of reasonable allegation. The landowner being recorder of the surveyor of Fradswell is almost certainly suggestive of a public right-of-way passing through the plot, as the surveyor would not have wanted to take on unwanted maintenance responsibilities. The Fradswell Tithe Map shows the physical existence of the alleged route, which is shown separate from adjacent taxable land holdings, coloured sienna, the same colour as other public routes in the area. The alleged plot has plot number 96A apportioned to it, and the award books list the plot use as a lane, with the landowner as Elizabeth Bree. This suggests that the land was in production, and whilst the status of such rights are not conclusive, it is suggestive that a public right-of-way of some description existed over the alleged route. The Ordnance Survey maps indicate a through route along the line of the claimed route, and whilst they are unable to provide any evidence as to the status of the route in question, Ordnance Survey maps can provide evidence of the physical existence of the route. Upon circulation of the report, the landowner provided additional comments which have been provided to members as an addendum at Appendix H. The landowner is opposed to the creation of the public right-of-way and questions the reliability of the deposited railway plan. The landowner considers that there is an omission from the plan of another footpath within the vicinity and that the omission casts doubts over the validity of the deposited account. The landowner believes that the allegation that the track is a public footpath is without merit. Officers' responses can also be found at Appendix H. Both the tithe map and the railway plans were produced by professional people at the time, and the surveyors involved were unlikely to be wrong. As such, they are often the best evidence that we have to rely upon when establishing public rights of way. all the maps were produced for different purposes. It is quite probable that footpaths or other routes may not be shown either fully or at all. For example, a footpath might be missing from a tithe map because the route was still in production and therefore still subject to the tithe. As such, it might not be depicted through any plot. We have to take all the evidence together to arrive at the most likely conclusion about the existence of public rights of way. The legal test to be applied for this application is under section 53 3CI of the Wildlife and Countryside Act 1981. Therefore, there are two tests to be considered: that of the balance of probabilities, whether the route subsists, or reasonable allegation, whether it can be reasonably alleged that the route subsists. In conclusion, the probity of the evidence from the Railway Deposited Plan, with the reference to the surveyor of Fadswell and Parish Road, together with the tithe map, provides strong evidence that the alleged route is a public right of way. As such, there is enough evidence to satisfy the lower test of reasonable allegation, and officers recommend that the application be accepted and an order be made to add the route with the status of public footpath to the definitive mapping statement for the Borough of Stafford. Your officers further recommend that the route should be to the minimum width of 1.5 metres throughout its length. Thank you. I'm happy to take any questions.
I'd just like to thank officers for their report. It's very comprehensive. I don't have any questions, but I'd be happy to approve.
I'm content with the report as it stands. Are we in favour? So the recommendation is that the evidence submitted by the applicant and that discovered by the County Council is sufficient to reasonably allege that a public footpath subsists, and that an order be made to add the alleged public footpath as a right-of-way shown on the map marked A to B and Appendix B of this report to the definitive map and statement of public rights of way of the Borough of Stafford. Thank you. That's approved. The next item is item 5, Wildlife Countryside Act 1981 application for the addition of a public bridleway along Glasshouse Lane from public footpath 56 by the road to Chipnell Mill to public footpath 71 by the road at Glasshouses Loggerheads. Thank you.
Thank you, Chair. So this is an application for the addition of a public bridleway along Glasshouse Lane in the parish of Loggerheads. So the application was submitted based on historical and documentary evidence. The evidence submitted with the application consisted of a 1910 Finance Act plan map, a tracing of a deposited railway plan dated 1845, a tracing of a Drayton and Hales tithe map, a 1932 Rights of Way Act deposit map, OS maps, and a Wright and Charrington motoring, cycling and touring map. So if we turn to the evidence first. So officers have reviewed the Drayton and Hales tithe map, and it shows a route running along the same line as the alleged route. The route is numbered 298 and it connects to Chipnell Mill and what appears to be the parish boundary to the south. The apportionment for the route number 298 states that the landowner was Thomas Hudson and the description given for the way is a road. The fact that a specific landowner has been listed as owning the route might suggest that the route is private. However, the fact that at the southern end of the route it refers to Chipnell Mill, this might suggest that the route was indeed public. The fact that the route is shown separate from the adjacent land and is referred to as a road is highly suggestive that the route has rights over it higher than a footpath. When considering the railway deposited plan, officers have also reviewed this, and again there is a route running along the same line as the alleged route, and this is numbered 26. The map shows Route 26 separate from the adjacent land, and it connects to the area of Chipnell Mill to the south. The plan does not show where the route connects to in the north. The Book of Reference records Route 26 as Highway, Surveyor of Highways. Therefore, the railway deposited plan evidence supports the physical existence of a route along the line of the alleged route. It also supports the route being public at the time the plan was drafted, as the Surveyor of Highways is listed as having responsibility for the route. Therefore, this could be persuasive evidence of a public right of some description. What is not clear from the documentation is the exact nature of the rights over the alleged route, as the term highway is a generic term and it does not provide any clarity as to how the route was being used at the time. When considering the 1910 Finance Act evidence, again, a route is depicted along the same line as the alleged route, and it is shown separate from the adjacent land. The fact that the route is shown separate from the adjacent land could suggest that the route was a public highway. Equally, it could be said that the route is shown excluded because there is no owner and that it was a private right-of-way. So the Finance Act evidence supports the physical existence of a route along the line of the alleged route, and that the route was likely to have rights over it higher than a footpath or bridleway, as the route is shown separate from the adjacent land. However, there is nothing to indicate the exact nature of the rights over the alleged route or whether the route was in fact public or private. When considering the OS maps and the Wright and Charrington map, these maps all show the physical existence of a route along the line of the alleged route. These maps do not provide any evidence as to the status or nature of any rights over the alleged route. When we consider the 1932 Rights of Way Act documentation, the 1932 Rights of Way Act contained a provision that allowed landowners to deposit at any time to the County Council a map and statement indicating what routes they admitted to being public rights of way across their land. The declaration was valid for 6 years and meant that during this 6-year period, no additional public rights of way could be dedicated or considered to have existed over the land in question. The map provided as part of this documentation is an OS map depicting the Drayton and Hales area. On the map is marked in red the boundary of the Hales estate. In the area of the Hales estate, some routes are coloured yellow and some routes are coloured an orange-brown. The key with the map shows that routes coloured yellow were considered footpaths and routes coloured orange-brown were considered to be roads. The northern section of the route, which connects to glass houses, is numbered 2A and is coloured orange-brown. The southern section of the route is not part of the Hales estate. The alleged route connects to a footpath to the north and the estate boundary to the south. Therefore, the documentation supports the physical existence of a route along part of the alleged route. It supports the northern section of the route being public and that it had rights over it higher than a footpath, although it is not clear from the description road what the exact nature of the rights were considered to be over the route at that time. The applicant then did submit some further documentary evidence in relation to the application, following investigations commencing on the application, and the applicant disagreeing with officers' initial interpretation of the evidence. This further evidence included the National Street Gazette. This shows the alleged route as Glasshouse Lane and it is recorded as having no classification, but the route is maintainable at public expense. The fact that the route is on the County Council's list of streets is supportive of the route being a public highway, as the County Council would not want to take on maintenance responsibility for the route unnecessarily. However, the list of streets is evidence only of whether the local authority has maintenance liability for the route. It gives no guidance as to the nature of any public rights that exists over the route. The applicant also provided a document listing streets in Staffordshire that shows the alleged route is recorded as an unclassified road. Even though the route is recorded as an unclassified road, this does not automatically mean that it has public vehicular rights over it. The term unclassified road has no legal meaning in terms of defining what rights exist over them. On submission of the application, one landowner was identified and they initially advised that they did not consider the alleged route to be public and that they had never seen or given anyone permission to use the route. Also following submission of the application, the Byways and Bridleways Trust responded to the application, advising that they supported it. Loggerheads Parish Council also responded, advising that they had no strong objection to the application, but they did query access to the proposed bridleway if it was found to exist. Following circulation of a draft report, comments were received from Mitchell Moore's solicitors on behalf of the landowner identified on submission of the application, objecting to it. They contend that the applicant has not provided any evidence of use of the alleged route and they have failed to show dedication by the landowner. They also contend that the historical evidence submitted by the applicant is insufficient to meet the threshold, either when considered separately or cumulatively as a whole. They have taken each piece of historical evidence submitted by the applicant and provided comments as to why the evidence does not show a public right-of-way along the line of the alleged route. This can be seen at Appendix K, L and M. They further state that the list of streets is not a definitive record of public rights-of-way and no public maintenance work has ever been carried out to the route. A second landowner was identified following circulation of the draft report, and they also provided comment on the application. They object to the application and they raise concerns about members of the public accessing their land and causing disruption to their livestock. So when we consider the relevant legal tests, the application is made under Section 53, 3C1. Therefore, there are two tests to be considered. That is whether the evidence shows on a balance of probabilities that the alleged route exists, or a lower test of whether it can be reasonably alleged that the route exists as a public right-of-way. So just to summarise, none of the pieces of evidence individually can be considered evidentially strong. However, each document has provided some evidence in support of the application, and specifically the existence of a public right-of-way along the line of the applied for route. Although there is evidence that the route status is likely to be higher than a footpath, the descriptions given of the route do not clearly identify the nature of the rights over the route. In light of the strong evidence of the route's physical existence and the fact that the route is not depicted as a minor highway, but there being no clear evidence that the route was used by carriages or carts and therefore would have had vehicular rights over it, the applied for status of a public bridleway is appropriate, given that the route was more than a footpath but not necessarily used by carriages and carts. So when all the evidence is considered together, as there is no one piece of evidence that is evidentially strong in showing the existence of the route with a particular status and the nature of the rights over the route, officers consider that the evidence is insufficient to show on a balance of probabilities that the route exists as a public bridleway. However, when considering the lower test, given that several pieces of evidence have been provided that have given an indication regarding the route's existence and the status and rights over the route, officers consider that the evidence is sufficient to reasonably allege the physical existence of the route with the status of at least a public bridleway. Therefore, to conclude, it is officers' recommendation that the evidence is sufficient to reasonably allege the existence of a public right-of-way as a bridleway along the line of the alleged route, and therefore an order should be made to add the alleged public bridleway to the definitive map and statement of public rights-of-way. Thank you, and I'm happy to take any questions.
Jack.
Thank you very much, Mr. Vice Chairman. It's not so straightforward, this one, but I'm happy to go with officer's recommendation.
Thank you. I'm happy to go with the officer recommendation as well. So the recommendation is that the evidence submitted by the applicant and that discovered by the County Council is sufficient to reasonably allege that the alleged public bridleway, along Glasshouse Lane from public footpath 56 by the road at Chipnell Mill to public footpath 71 by the road at Glasshouses Loggerheads subsists, and that an order under section 53 3CI should be made to add the alleged right-of-way shown on the plan attached to Appendix B and marked A to B to the definitive map and statement of public rights-of-way for the district of Newcastle as a public bridleway. Are we in agreement with that? That's agreed, Zach. I think that takes us to the end of our meeting. So those are the two items that we need to consider this morning. Can I thank you very much for your very clear and precise reports. Jack, can I thank you for coming in? I do apologise for calling you Zach. And thank you for the members of the public that are here. So thank you very much, and I close the meeting at 10:20. Thank you very much.